Hi, and good afternoon. Happy Friday. Thomas Hyman here with a quick realtor tip of the week. What do you do when you're working with a power of attorney and something happens and the principal dies? Now, that may sound dark, but truth is, here in Florida, most of the time, sometimes somebody will use a power of attorney because somebody's out of town or out of the country in the service, but most of the time you're going to use power of attorneys or see power of attorneys when somebody is elderly or sick and not able to execute documents themselves. So what do you do if you take a listing, for example, or write a contract for that matter, but most importantly, when you take a listing and somebody's using power of attorney, the attorney in fact signs the documents, and now the person passes away. The principal, the person that gave the power of attorney, passes away. I've seen this happen a few times actually in my career as a broker as well as a title agent, and it can open up all sorts of cans of worms. The first answer to this question is it depends. So if you have a husband and wife, for example, and they own a property jointly, and the husband gives power of attorney to the wife, and now the husband passes, if the property is owned by them as husband and wife, then the wife automatically becomes the sole owner. There's no need for probate or anything, and you just move forward with the wife as the sole owner. So when an offer comes in, she would execute the properties as the sole owner. The only thing you would need in your file is a copy of the death certificate. But what if the property is owned by, let's say, an elderly person and their kids have power of attorney, and now that person passes away? In a situation like that, the property has to go through probate. The power of attorney becomes null and void the second the principal passes, and so that means that you cannot have the attorney in fact move forward to close the transaction. So the property has to go through probate. There's no way around it. And the biggest issue that I've seen a couple of times happen is that, let's say you take a listing and the daughter is the attorney in fact for her parent, and the parent passes away, and the daughter never tells you about it, and an offer comes in, the contract is executed, the daughter signs it as attorney in fact after the person had passed, and now you have a situation where the contract is null and void. So whenever you're dealing with a power of attorney, especially with someone that's elderly or ill, you want to make sure that when an offer comes in on your listing, that the principal is still alive. So short tip of the week. Hope you found this informative. If you did, please check back again next Friday and have a wonderful weekend. Thomas Hyman here. Bye.